What is dram shop law?
Hi friends, and welcome back to our series of frequently asked questions. I'm Jim Adler, the Texas Hammer. Today we are going to talk about an area of the law known as dram shop law. We'll explain what it is and how it could affect you or someone you love.
Drunk driving is a huge problem in the United States. Statistics from the National Highway Traffic Safety Administration reveal that 28 people die every day in the United States from drunk drivers, adding up to over 10,000 people each year. This is a big problem in Texas too, with the Texas Department of Transportation providing statistics that show almost 1,000 DUI alcohol-related fatalities in our great state. Liability for a drunk driving accident is not just imposed against the drunk driver or the vehicle owner, but liability could also be imposed on a business or third party that served or provided alcohol to an intoxicated person who caused the crash. This type of liability is called a dram shop law. Like every other state, Texas has strict dram shop laws which allow victims and their families to bring a claim against a negligent party who served or overserved alcohol. This liability includes against bars, restaurants, clubs, party hosts, private resident called social hosts, rod and gun clubs, event organizers, or any other individuals who provide alcohol to an intoxicated individual or a minor. Dram shop laws break down into two categories of liability. The first is against bars, restaurants, and other organizations or parties licensed or permitted to serve or sell alcoholic drinks to others. One of these defendants could be liable for a Texas drunk driving accident if they served or sold alcohol to an obviously intoxicated person who is a clear danger to himself and others. If that intoxicated person was the cause of the victim's injuries, the business could be liable. The second category of liability is a social host liability law. This set of laws applies to vendors and social guests like homeowners or parents who are 1. At least 21 years old, and 2. Provide alcohol to a minor. A social host could be liable for personal injuries if an intoxicated minor caused an accident where the minor was under 18, the defendant was not the parent or custodian of the minor, and the defendant knowingly served alcohol to a minor, resulting in the intoxication. In addition to these elements, like a dram shop claim against a bar, the minor must also be the cause of the victim's injuries. Dram shop cases are complicated to prove because defendants often have many defenses to liability that insurance companies and adjusters will try to use. This is why victims injured in any type of DUI accident in Texas, where a bar, restaurant, or even private social host may have overserved the defendant, should call an experienced Texas accident lawyer like one of ours at Jim Adler & Associates. We can help protect your rights under the law, including filing a dram shop claim against all possible parties.
If you have questions about this information or would like to discuss your dram shop case, you can get in touch with Jim Adler & Associates by way of the contact form at jimadler.com or by giving us a call at 1-800-567-7575. Again, that's 1-800-567-7575.